Okay, well, it just turned 11 a.m., our official start time, so let's jump right in. Welcome, everybody. Thank you for taking the time to join us today for this live event to talk a little bit about cookies, and not the chocolate chip kind, and the legal and, oh, looks like we're only live now. So let me start again. Welcome to everybody. Thank you for taking the time to join us today for this little live event to talk about cookies. And like I just said, if you heard it, not the chocolate chip kind, but the technical kind. Welcome also to Mia Munck Bruns, my co-presenter today from Cookie Information. I am Christian Engelhardt, partner in the Hamburg office of Baker Tilly, a lawyer and responsible for intellectual property, IT, and data privacy issues. So obviously I will be speaking a little bit about the legal framework and requirements surrounding cookies, and then I will hand over to Mia for the more technical side of things and proper implementation of those things that you have to do to stay legally compliant.
Thank you for having me. Thanks for inviting me.
Well, thanks for joining. It's a pleasure to present with you. And like I already mentioned earlier, maybe not all of you were here yet, all participants are anonymous, and questions that you post to the Q&A will also be posted anonymously. So please don't hesitate to ask any questions, and we'll be happy to answer them after the presentation of both the legal and the technical side of things. That being said, well, for some reason, the presentation is not there. An online presence overview is something I don't have a slide for, because I think we're all familiar with websites and what online presences look like. Mia, please.
Sorry to interrupt. The screen or the PowerPoint is actually still gone. Maybe if you want to try again, and I can briefly say that in the meantime, of course, I will be presenting the technology part. I'm a country manager for our German-speaking clients with Cookie Information. And yeah, so I will talk about the technology, the Google Consent Mode, how to improve your data. All right, perfect.
Can you see it now?
PowerPoint is back, yes.
The proper mode. Okay, so there's no slide for the first agenda item, because I think we're all familiar with websites and what they look like. What matters here for the purposes of our talk today is the data flow and the use of cookies. Assuming that you're generally familiar with what cookies are and what they do, users who access your website obviously do things there. They look at things, they purchase services or goods, and as the website operator, you have an interest in knowing what exactly they do, analyzing that to improve your offerings, and that data that is collected inter alia by cookies is then used by the website operator or transferred to third parties for analytics purposes or other things that may be useful in that context. Now, the legal framework of things here, because the starting point is that cookies do collect data, is obviously the ePrivacy Directive and the General Data Protection Regulation. It's important to note that both require a legal basis for collecting and processing data, or in case of the ePrivacy Directive, also for storing information on a user's device, which cookies basically do. Article 5 ePrivacy Directive has to be the first point to address, because it requires consent for pretty much everything that is cookie related, except so-called necessary cookies, which are generally, it's different for every website, but good examples would be like a shopping cart function, and things that have been already contractually agreed with the user or that are necessary to provide the service, and without those it wouldn't work. But for everything else, Article 5 requires an express consent. As soon as personal data is concerned, which is pretty broad, including even the IP address if it's not anonymized, the GDPR in Article 6 also requires an express consent or another legal basis. GDPR does contain other legal bases for collecting and processing data. However, that does not override the e-privacy directive. So the consents for in the GDPR, for example, for fulfilling a contract, don't do away with the Article 5 EPD requirement. Where a consent is required, it has to be what we call in legal terms an express informed consent, and that, in order to be valid, has to fulfill a few standards. First of all, it is now clear, after it was debated for several decades, that every such consent has to be active. It has to be an active decision by the user to allow the use of cookies or allow the collection of data. So opt-in solutions are the go-to. Opt-out solutions, where a user has to uncheck a pre-checked box, for example, or click a link and choose to exclude certain data or exclude certain cookies that are pre-checked, is not permissible. In order to be valid, the consent also has to be based on the user being properly informed and proper transparency, meaning the user, when giving the consent, has to have the information what cookies are being used, or has to have access, direct access to the information, what cookies are being used, for what purpose, what's the duration of use for personal data, what third parties may have access to the data collected, and which countries is such data transferred to, if any, outside of the EU. That also includes information about user rights, so the famous right to be forgotten. Once a user has granted consent to the collection of data, it has to be possible to demand the deletion of such data, or correction if it is incorrect or something has changed. And also there has to be an easy option to withdraw consent, and it has to be essentially as easy as granting the consent. And of course, all these consents, or the declining of consent, has to be documented and properly managed. But from that starting point, that is relatively clear-cut, there are some legal challenges and gray areas associated with this. First of all, the question whether a cookie is necessary or optional within the meaning of Article 5 EPD is not always clear-cut, and has to be analyzed on a case-by-case basis. You have to look at your website, your online presence, and think about what actually is necessary and what is not. So, for example, for an online shop, that is different than for a news site. When requesting consent from the user, it's important to know about nudging and dark patterns. These are two shades of the same palette, where it's about getting the user to give consent in a way that is more or less open or more or less deceptive. Nudging refers to the, let's say, lighter shade of this, where you choose to design your consent request in a way that, well, nudges the user to grant consent. It becomes slightly more attractive to grant consent than not. And where that is permissible, or to what extent that is permissible, and where it becomes illegal, is a bit of a gray area, but there are some lines. For example, to use an example that was debated in court already, you can't or you shouldn't have the accept all cookies button very large and green, and the decline all cookies button as a stop sign, and it doesn't even say decline, it says take me out of here or something like that. That's almost a dark pattern. And dark patterns are the darker shade of these this psychological trick to get users to consent, where you actually almost deceive the user, or actually deceive the user into granting consent. So it's very important to be careful about the design of the consent request, and get proper advice and then proper implementation advice on that. Cookie walls are also an area where not everything is entirely clear-cut and decided. As a starting point, a cookie wall, meaning you can only get access to the site if you consent to the use of cookies, is generally not permissible. The exception may be so-called pay or OK schemes, or paywalls combined with cookie walls, where there have been decisions that if you combine or if you tell a user you can either pay for this website and using it, or you can grant consent and get access to it for free, that is can be permissible. Another legal challenge, not so much in light of the privacy directive, but in light of GDPR, is now Schrems 2. For those of you who are not familiar with the term or the decision, it's a European Court of Justice decision where the European Court of Justice invalidated the so-called EU-US Privacy Shield that allowed for the legal transfer of personal data from the EU to the US. And the ECJ concluded that after that is invalid, such transfers are technically still possible using the standard contractual clauses provided by the EU Commission, but may require additional technical measures or organizational measures to ensure a data privacy level in the recipient country that is substantially equivalent to that in the EU. And the onus and then the work was put on the website operators, on the data controllers, to make that assessment and implement the measures that they believe fulfill this threshold. And as a result, the risk of getting that assessment wrong is also on the individual data controllers. So the ECJ has really left us with in a bit of a pickle there, and it's very contentious right now how data transfers to non-EU countries is still legally and safely possible. I'm not going to get into every detail of that here because that would be another hour of discussion just about Schrems 2. But as soon as personal data is concerned, that is a hot topic and a very contentious area, and concerns, for example, Google Analytics, MailChimp, and many other US providers that are widely used. As a little bit of an outlook, will there be a Privacy Shield 2? Maybe. With the new administration in the US, at least there are talks about how to resolve this situation. But we don't know where that journey will lead or if Mr. Schrems will challenge that again. Revised, reworked standard contractual clauses are already in the works, and we may get more and better, less confusing guidance from the European Data Protection Agency and individual data protection agencies in various countries. That remains to be seen what the developments are. And then, of course, if e-privacy regulation ever comes into force, that may address some of these issues as well, including in particular some specifically cookie-related issues, like is a consent required even if the data is anonymized, which can be said is required under e-privacy directive, but could also be argued cannot be required because what's the interest? But that is another contentious area. So from a legal perspective, what are your to-dos as a website operator? Or of course, you need to understand what it is that you actually do. Take stock, assess, and document your current use of cookies. What do they do? What's the functionality? Can they be classified as technically necessary for the site that you're operating? What data transfers do occur, both on a geographical level to non-EU countries, but also to which third parties, if any, and for what purpose? The consents that you've gotten or that have been declined or withdrawn should be documented and properly managed, so you're always up to date with that. And then based on all of that, you need to potentially do a full-on risk assessment of the data transfers that occur in the context of your online presence and document the result of your assessment. After all that, you should then, if you've identified any need for change, evaluate that need for change and implement or update your processes, both from a legal side and technically. And then, the second to last bullet is not necessarily a legal issue, but of course, design your consent management in a way that is compliant with the law, but that is still smart. So I'm not saying you should nudge. You should definitely not use dark patterns, but you can still create a consent request or a consent question that is attractive to the user. And lastly, in that context, you should evaluate the technological options that you have to ensure compliance with the legal requirements and make things easy and usable for both the users of your website and yourself. With that being said, I welcome any questions, of course, on the legal side of things at the end, but now I would like to hand over to Mia and let her talk a little bit about what cookie information does and what the technical side of things looks like. Thank you very much.
Well, thank you, Christian. And I will start sharing my screen with you all. And if you'll be so kind as to confirm, Christian, if my presentation is visible, that would be great.
I cannot see it yet.
Really?
Yes, yes, it is.
Yes, it is. Great. Terrific. Well,
yeah,
thank you.
I can see it. Thank you.
Super. Thank you, Christian, for highlighting the legal framework when it comes to cookie compliance on websites. And this is where technology comes into the equation. And this is what we do at Cookie Information. We're a content management provider. And since 2011, we have been helping, and we are helping companies worldwide with documenting their cookie compliance on websites as well as mobile apps. So we provide the technology, and we also offer audit and technical support. Okay, so this is how it can look. I'm sure you've seen different kinds of banners all around the internet. This is our interpretation as how to collect, how to comply with regulations that Christian just highlighted, and how to collect valid consents. All right, this is how it works. This is how our technology works. This is a more dissected view of the banner I just showed you from our own website. Our technology ensures that visitors, website visitors, can actively and selectively opt into cookies. What our technology also does is it informs the user about the cookies that are being set. So what Christian just highlighted, the up-to-date information on purposes, on lifespan, on description. So that's something we also provide. We also store each and every consent collected for 5 years so that your compliance is documented in case of an audit, or if it's called a DSR, a data subject access request, reaches you by a private person. And what our technology also does is it blocks data processing. So this means that prior to consent given, all cookies are being blocked, apart from the technically necessary cookies, till our CMP, our content management platform, registers that a user has given his or her consent. Till that moment, marketing, statistical, and functional cookies are being blocked. And after that, of course, they are released in accordance with the consent that has been given. All right, so this is how it should look like in your browser. The upper picture is prior to consent given. You see the disclaimer is loading. You see a blank list on the right-hand side. This means that no cookies are being set at this stage. On the second picture, you see that the banner is gone, the consent has been given, and you see a list of cookies that are active. This is after the consent. And this is something that anyone can check in his or her browser. You can check this in your browser yourself, or if you need help with that, of course, we can help you with your compliance level, with a compliance check. So far, so good. So now that we know how consents are being collected and documented, it's interesting to take a look at how is the acceptance rate? How do users react to cookie banners? We have 7 different templates, and I've chosen one to give you an idea of how users react to a cookie banner when consents are being collected. So these data are from the past 30 days across industries, and on the left-hand side you see Germany, And this is an average of 78.5 of users saying yes to cookies. On a global level, we see an average of 77.2 of users saying yes to cookies. So if we're rounding up here a bit, this means that 80% say yes to cookies. What this also means is that 20% say no to cookies. And well, one might think that 20% isn't that much, but considering that 29 million websites today in Germany use Google Analytics and Google Ads to support them in driving their business, we're talking big numbers here, especially considering that e-commerce is on the rise due to COVID. And we all know the business of Google. The business of Google is to find the most suitable buyer for a company's product in accordance with that user's search behavior profiling. So in order to cover for these 20% who say no to cookies, Google came up with Google Consent Mode. And what is Google Consent Mode? What does it do? It came out last year in October. It's still in a test phase. And the information that I will be sharing from here is from a webinar Google did last Thursday night. So this is the newest available information on Google Consent Mode. And Google Consent Mode is a set of rules that you can implement into your website, and it will collect anonymized data in a privacy-friendly way to give you an estimate of conversions of the users who have said no. Okay, so far so good. So I've tried to break down the previous chart that is from Google into a more simplified version to give you an idea of what happens in Google Consent Mode. What does Google Consent Mode do? I believe we all know what happens when someone says yes and cookies are being, they read and write, identifiers are active. We're interested in knowing what happens when someone says no in Google Consent Mode. So instead of tags being blocked, Google Consent Mode and the CMP will communicate. So when someone says no, the CMP tells Google Consent Mode someone said no, and tags are fired. Yet the difference here is that there's no identifiers that are active and no cookies are being set. So what happens is those tags will collect anonymized data. And the way Google describes it is there's 3 different kinds of events that Google Consent Mode collects data on and sends pings about. They call it pings. And there's it's about consent status, it's about Google Analytics, and it's about conversion. And the way they describe it is, so for instance, in conversion is ping someone who said no to cookies is on your landing page. And what does this data do, or how can this data be of use in Google Consent Mode? To give you a better idea of this, I've selected a scenario and or an event and 2 different scenarios, one without Google Consent Mode and one using Google Consent Mode. So this is about an ad event with 100 users. And the first scenario is we have 100 users clicking on an ad event. 10 of those users convert. So the basic math here is that 10 divided by 100 is 10%. So we have a 10% conversion rate reported. Using Google Consent Mode, it's, and they call it modeling, we have 2 paths from here. We have the one path of the 70% of users saying yes to cookies. Of those users, also 10% convert. So the math here is to divide 10 by 70, and we have a 14% conversion rate of consented users having converted in Google Consent Mode. And then there's this slice of 30 users having declined cookies. And we don't really know what happened. And this is where the pings come into the equation and the anonymized data. And what happens here is that Google Consent Mode will use the anonymized data to compare non-consented user behavior with consented user behavior and give an estimate of a conversion rate. So you will end up with an estimate about the non-consented users having converted to a paid ad event. And this is a way of recovering the data loss of the set 20% in a privacy-friendly way. What the benefits of this are is that you will retain measurement accuracy, and you will get a fuller and better picture of your data. And with this information, you will be able to optimize your marketing strategies, optimize your marketing spend. And yes, this is the most up-to-date information available at this stage. Google has announced that there's more information coming up on modeling, on the modeling part in Google Consent Mode by the end of Q1. So this is pretty much very soon, and Q2. What we can do for you is we can offer a CMP that collects and stores valid consents, and we are a official Google partner, so you will get a vendor ID as well, and it will be registered with Google that you are using a certified vendor, where the CMP communicates with Google Consent Mode. And this has been like an introduction to the legal framework and how technology can help you with complying with the legal requirements, and how Google Consent Mode can help you to improve your data. And up next, we will be answering the questions that we have received from you. And now is a really good time to use the chat. If you have any questions, please ask away, because there will be a Q&A after we've answered the received questions. Thank you. Perfect. Maybe Christian, if you
yeah, sure,
would like to answer the legal questions that you've received from the participants.
Yeah, no problem.
I will follow up.
Am I on again?
Yes, you are.
Okay, good. Yeah, now I can see it. Okay, let me look at some of these questions. Are there clear requirements how detailed the choices have to be? Is it okay if the user can only choose between accept cookies and settings? Well, there's a pretty clear answer to that. No, that's not okay. Accept cookies, of course, is okay, but the alternative cannot be settings or manage settings. I don't think that's a clear choice for the user. It's not transparent enough. There has to be more to it. So it has to say decline, or it has to give you an option of decline functional cookies or decline marketing cookies, something like that. But just saying settings, no, that's not detailed enough in my opinion. Okay, let's see, what else do we have? What will change under the e-privacy directive, e-privacy regulation? Well, unfortunately, I can't answer that exactly, because the e-privacy regulation isn't enforced and is still being debated, but I would expect that not a whole lot will change. I do expect, but that's speculation, of course, that the consent requirement that we currently have in Article 5 EPD will be detailed a little bit more and maybe amended to be in line with the GDPR a little bit more, but remains to be seen. I hope that helps a little bit, but unfortunately I can't say exactly what the law is going to be in the future. Are cookie walls always prohibited? Well, you know, like I thought I addressed that a little bit, but not always, no. Like I said, the pay or okay wall has been held to be okay, to be permitted, permissible, but there's no, as far as I'm aware, there's no decision by the highest courts in every land or the ECJ, but in I believe it was in context of, was it think it was in context of the Planet 49 decision, but I'm not entirely sure, that the general attorney said something along the lines of, yes, that is okay if the only choice is consent and get it for free, or pay, and so the data is essentially, the consent is essentially the payment for access. So I'd evaluate it carefully in each case, but that can be permissible. Okay, for now, I think that's all the questions that I've had so far. Hopefully there will be some more.
I have a couple as well that I can dive into. Is now a good time?
Yeah, of course,
Okay.
Go ahead.
Perfect. Well, one of the questions we've received is, how can I check my compliance level, my cookie compliance level on my website? And this is actually a really interesting question, because we get it a lot, and it's well, there's different ways of doing it. I will try to describe the fastest and the simplest way to do it. It's basically you need to open your browser in an incognito view, and then you type in your website or whichever website you would like to look up. And when you've done so, there will be in the browser where you've written down the website, on the left-hand side, if you use your cursor, there's the lock. And of course, don't do anything on the website prior. Don't give your consent. But click on the lock, and when you click on the lock, you will see 3 different informations unfolding. And in the middle of that, it says cookies. And when you click on the cookies, you will be able to see which cookies are active at that stage. Some of them are really easy to decipher, or to know a GA is a Google Analytics cookie, and that one shouldn't be active at that point. But there can, depending on, of course, the compliance level, there can be a longer list, and some of them are, some of them aren't that easy to understand, taking a first look. So, well, I would recommend you try this out, and if there's anything active at that stage, or you need help to find out what are these cookies at all, feel free to reach out, and we can help you with that. But that's essentially the easiest way to look, have a look at, is my website compliant? Are cookies blocked till the consent has been collected? And the next question I've received here is, do I need to inform about, do I need to inform about cookies? Do I need a cookie overview? And I think both Christian and I made it pretty clear that yes, this is required by law, that you have one part of giving a valid consent is the informed part. I think what's relevant to say here is that the information needs to be up to date. And the way we do it here is that our scanner scans a website, and it finds all the cookies that are being set. We have an internal database of over 200,000 cookies, and this database is used as a reference to generate this cookie overview about purpose, classification, description, lifespan, data processing, and it all depends on the needs. It depends on how many changes do you perform in your backend. Are you changing to a new third-party vendor? So meaning here is you need to have a look at what frequency is needed in order to ensure that information is up to date. So we scan either daily, weekly, monthly. It really does depend. What you need to make sure is that this overview is made available and that it is up to date. So yeah, so that's basically the questions I've received when it comes to technology and how you need to, what you need to integrate into your website to meet requirements, legal requirements. I have actually not had a look at the chat window yet. If there's any questions, have you seen, Christian, if there's any questions that have ticked in from?
Unfortunately, I don't see any.
No, there's a.
I, invite everybody again to post a question or two, but
maybe there's a consensual silence at this stage. But do feel free to ask away. I mean, any questions are welcome. And even, I mean, also just with the overview, it's these questions might seem quite common, but just ask away.
Well, and of course, if anything comes to mind later, and you feel free to reach out to us at any time, and we'll answer questions by email or phone.
Yeah, absolutely. I do believe there's a follow-up no matter what, that you will receive, or the participants will receive a link to the webinar that is being recorded. And as you were saying, Christian, of course, we're happy to answer any questions after the event as well.
All right.
Oh, yep. I'm supposed to, sorry, share information again about, of course, our contact details. And I need to make sure that I'm actually sharing this information with you now. Wait, hold on. I'm with you in a few seconds. Boom. All right. Thanks for reminding me about this. Can you see the presentation with the contact details?
Yep.
Awesome. All right. Well, we're still at this stage. At the same time, this is where you can reach us. If you have any questions, we're happy to answer them.
Okay. Well, I think let's give people another few minutes and see if anything pops up. But if there's nothing, then already thank you very much for your attention, for taking the time to listen to us today, and hopefully we can be of assistance if anything comes up.
Yes, likewise. Thank you very much.